Hello and welcome to BrokenCredit.com seminar. I'm Paul, the host of the Broken Credit blog, and today we're going to talk about foreclosure. Please pay attention for a moment. This is the most important part of the seminar. Never pay a fee or sign an agreement with anyone offering foreclosure help unless you first have that agreement reviewed by an attorney. There are many people offering foreclosure help these days, and all they really want to do is help themselves to your home's equity. But what we're going to teach you today are strategies on how you can keep your home's equity and how you can keep your home. While we're on the subject of foreclosure help, there are 3 places to go for foreclosure help. You ready? Number 1, an attorney. Number 2, a HUD-approved counselor. And number 3, your lender. Yes, contrary to how you may feel or what people may tell you, your lender is not necessarily your enemy. But what you're going to learn today is what to ask for from your lender, where you may stand with your lender, and how to keep your lender honest. We've got a lot in store for you today, and I'm aware that many of you are at various stages of foreclosure. Some of you are current and have not missed a payment. Some of you are past due and in imminent danger. Some of you may be moments away from foreclosure. And some of you may be watching this seminar today to help a loved one who may be facing foreclosure. Well, I'm pleased to share with you that there'll be something here for everyone. Our objective is that you learn some knowledge today and gain some confidence in formulating a plan to move forward. And for the majority of you, that means keeping your home and having a mortgage payment that you can comfortably afford. Okay? So let's get started. What is foreclosure? Well, your property is pledged as collateral for a loan. If you don't make the payments on the loan, then the bank repossesses it and sells it. So foreclosure is the legal process whereby an owner's right to a property is terminated. This process is governed by state law. There are 50 states plus the District of Columbia. Each state has its own rules regarding the foreclosure process. We're not going to get into each state's requirements, but we will talk about them in general terms. Some of the federal laws, like TILA, RESPA, and bankruptcy, we'll get into detail today. But there are also laws that are afforded you in your state. It's important to know because your lender is required to follow rules of foreclosure. And if you're unsuccessful in working out a workout with your lender that we're going to talk about today, then there are legal defenses to foreclosure. By the way, I am not an attorney, and this information in this seminar should not be considered legal advice. You must consult an attorney for legal advice. If your situation escalates to the need for an attorney, then I can wholeheartedly recommend the attorneys at the National Association of Consumer Advocates. Their website is NACA.net, N-A-C-A.net, and if need be, then they can help you with legal defenses to foreclosure. Okay? Step 1. What do you need to do? You need to start a file. What goes in the file? All the records relating to your home. Number 1, your purchase and sale agreement from when you bought the property. Number 2, your mortgage loan application. Number 3, all the closing documentation that you received from your title company, most likely in a folder from the title company from your last closing. Number 4, your property tax bills. Number 5, your property insurance information. Number 6, all of the letters you've received from your mortgage company, including the envelopes. And number 7, all the correspondence that you've sent. So all that needs to go into a file. Step 2, what do you need to do? Make a budget. You're going to need to make a budget. Now the purpose of making a budget is twofold. Number 1, you're going to need an accurate estimate of your income and expenses to present to the lender for them to offer you a workout. And we'll talk about that in a little bit. Number 2, what we're going to talk about right now are ways that you can save money on your budget. So you're going to need to look at ways to save money on your budget. Now, beyond the obvious ways of tightening a budget, I'm going to go over 3 specific scenarios which are going to apply to some of you today. Does anybody out there have a loved one who's a member of the military? You need to know about the Service Members Civil Relief Act. The Service Members Civil Relief Act requires the interest rate on any obligations that were taken out prior to the service members entering active duty. Now, this would be a mortgage, car loan, credit cards, payday loan, home equity line of credit. Any of those obligations that were entered into before the service member entered active duty, the interest rate has to be reduced down to 6%. This reduction in interest rate is also a reduction in the monthly payment. It applies to co-signers as well. So if you're a co-signer with the service member, you get the benefit also. This reduction can amount to a huge savings for the service member and the service member's family, but the service member has to ask for the reduction. What the service member needs to do is take the military papers that the service member has being called to active duty and send that to their lenders where they have these loans. They have to send it to them within 180 days of termination of active duty, and it's effective as of the date they're called up to active duty. So make sure that you are benefiting from the Service Members Civil Relief Act if this applies to you. Does anyone out there have any student loans? Let's talk for a moment about student loan deferment forbearance. For those of you who are not in default on your student loans, you may qualify for student loan deferment. Through deferment, you don't have to make payments on your student loan. You also don't have interest accruing on your student loan. Deferment may be granted for the following reasons. Number 1, unemployment, granted not to exceed a 3-year period. Number 2, an economic hardship deferment, which is granted 1 year at a time for a maximum of 3 years. And number 3, there's also a deferment for members of the military. Now, if you are in default on your student loan, you don't qualify for a deferment, for a student loan deferment, but you may qualify for forbearance. The Department of Education has discretion to grant forbearance, and in many cases must grant forbearance for the following reasons. Number 1, the borrower is in poor health or experiencing some personal problem that is making them unable to pay the scheduled monthly payments. Number 2, the borrower has filed an application for consolidation. And number 3, the borrower is unable to make the scheduled payments within the maximum repayment term. Keep in mind that in general, student loan payments must be reasonable and affordable. If you have a student loan, then go to the Department of Education's website at ed.gov, ed.gov, to find out about information about student loan deferment, forbearance, and repayment options. Does anyone out there pay monthly mortgage insurance? The Homeowners Protection Act of 1998 requires the cancellation of mortgage insurance when the LTV reaches a certain level. Actually, it requires the cancellation of mortgage insurance when the LTV reaches 78%. Now, the LTV is the loan balance that you have now divided by the, in this case, the value of the property when you purchased it. So when you reach 78%, when you have 22% equity in the property, the Homeowners Protection Act of 1998 requires the cancellation of your mortgage insurance. That's not a big deal because it requires the cancellation. But if you are at 80% LTV, not quite 78%, so you have 20% equity in the property and not 22% equity in the property, you can cancel the mortgage insurance by writing into your lender to cancel the mortgage insurance. The requirement is that you have a relatively good payment history on your mortgage, which means that you haven't been 30 days late in the past 12 months and you haven't been 60 days late in the past 24 months. That monthly mortgage insurance figure, I know in some cases, sometimes that's as much as $600 a month, so that might be the difference between making your loan affordable or not. Now, Fannie Mae and Freddie Mac, if you have a Fannie Mae or Freddie Mac loan, they have their own allowance in addition to the Homeowners Protection Act for canceling mortgage insurance. And theirs is based on the value today, your appraised value today. So if you have 25% equity in your property based on the appraised value today, and you've had your loan for 2 years, then you can write in and cancel your mortgage insurance with Fannie Mae and Freddie Mac loans. One final comment about making a budget. The general priority is food first, then mortgage, then utilities, then secured debts, which would be like a car loan, and then credit cards last, which is unsecured debts. Okay, now what we're going to talk about are your options. You need to know your options, step number 3. You need to know the various loss mitigation options and when and under what circumstances your lender is likely to help you. First thing that you need to know is that if you have a lot of equity in your property, say you have $100,000 equity in your property, your lender is less likely to help you with loss mitigation options, because if you have a lot of equity in your property and you're past due in your payments, they're more likely to foreclose and sell the property and cover their loan amount that way. But if you have a lot of equity in your property, you're not in a bad situation, because you can refinance the loan or you can sell the loan. One refinance program that's available when you have a lot of equity is a program called a foreclosure bailout. The way a foreclosure bailout works is it's a lender that makes a loan to you to pay off the loan that you've got, and it's just based on your equity position in the house. There are 2 types of foreclosure bailout lenders. There's institutional lenders and there's private lenders. Institutional lenders are licensed companies that are in the loan business, and private lenders are just individuals. As an example, if there was someone named Fred that made the loan to you. If you do a foreclosure bailout loan, you only want to work with institutional lenders. If you have an individual that makes a loan to you on a foreclosure bailout loan, there's a danger that this person may be making the loan to you because they want to be the next one to foreclose on you. So you have an added level of protection when you have an institutional lender helping you with a foreclosure bailout. And then, of course, if you have a lot of equity, the other option that you have is that you can sell the property. And if you sell the property, then you retire that debt, you turn that equity into cash, you've got money in the bank, and you're starting again. So having a lot of equity is not necessarily a bad thing. But what I want to talk about today, and there is a situation that's going to affect a lot of people, is that when you don't have a lot of equity in the property, for those people that have very little equity or no equity in the property, the good news is that the lenders are more likely to help you when you have little to no equity in the property with one of the following loss mitigation options. First is repayment plan. If you can begin making scheduled monthly payments again, plus an additional amount towards the arrearage at scheduled intervals, then you can enter into a repayment plan with your lender. Now that's no revelation, that's nothing really surprising. You are able to get into a repayment plan. Something a little more interesting for a loss mitigation option is a forbearance plan. Now, a forbearance is a written agreement that you enter into with your lender which can reduce or suspend your mortgage payments for a specified period of time. Now, a forbearance plan can be a lifesaver to millions of homeowners out there of not having to make a payment for a specified period of time. A forbearance plan is in the hands of your lender to offer to you, but what you need to do is to submit the proper documentation to your lender for them to approve you for it. We're going to talk about a forbearance plan again. It's a great solution for a lot of people. Another one, and probably my favorite, would be a loan modification. A loan modification will permanently modify your original note. The original note that you closed on, your promissory note, the terms of your note can be permanently modified in a loan modification. What that means is that it can permanently reduce the interest rate on your loan. It can change an adjustable rate to a fixed rate. It can extend the term of the loan. Okay? It can capitalize the delinquent payments. So if you're past due, it can take the amount that you're past due and add it back into the loan. A loan modification is an excellent foreclosure prevention tool and a great workout. We're going to talk about that again too. Another option is a mortgage assumption. Now, if you have somebody that wants to purchase your property and they want to take over your loan payments, your lender can approve them to do that and release you from the loan. Another option is, let's say that your loan balance is up here, okay, and your property is worth less down here. Another workout option is a short sale. Someone can come in, a buyer can come in and purchase that property at this lower price, and the lender satisfies the debt for that amount. Short sale is a great foreclosure workout avoidance tool also. And finally, another option is a deed in lieu of foreclosure. Deed in lieu of foreclosure is essentially an option of last resort. It's where the borrower conveys the title back to the lender so the lender doesn't have to go through foreclosure. So these are your basic options. If you have equity in your property, you can refinance through a foreclosure bailout loan, or you can sell the property if you have a lot of equity. And if you don't have a lot of equity, then you can enter into a repayment plan. You can do a forbearance agreement. You can do a loan modification. You can do a mortgage assumption. You can do a short sale, and you can do a deed in lieu of foreclosure. We're going to talk about these options here again, and we're going to add a few more to the list. Now what I want to talk about is the documentation that is needed for a workout. Your mortgage company has different departments. They have the departments that your mortgage company has don't necessarily communicate well with one another. The different departments are escrow, collections, loss mitigation, bankruptcy, foreclosure, and real estate owned department. The department that you need is loss mitigation. You're going to likely be routed to the collections department. You want loss mitigation, so you'll have to be persistent. When you get through to loss mitigation, you need to request their workout package. Okay, each lender has their own package. You need to request it. You don't necessarily need to be delinquent on your loan to talk to loss mitigation. According to Freddie Mac, to qualify for a workout, the borrower either needs to be past due in their payments or in imminent danger of default. What kind of danger are we talking about? That brings us to the hardship letter. In general, most mortgage lenders will only offer a workout to someone who is experiencing some type of financial hardship. What is a financial hardship? It's something that resulted from an involuntary reduction in income or an unavoidable increase in expenses. There's an example of a hardship letter on the Broken Credit blog, a hardship letter requesting forbearance. Writing a hardship letter is very simple. First paragraph, state your foreclosure prevention tool. Forbearance, loan modification, short sale. That's in the first paragraph. Next paragraph, describe the hardship and the reasons for the hardship. I voluntarily quit my job for no good reason. Bad example of a hardship. Remember, it's got to be an involuntary reduction in income or unavoidable increase in expenses. So I was laid off from my job. I had medical expenses. My spouse lost the income, lost their job. These are examples of a hardship. Next paragraph, give an overview of your income and expenses. It should also list whether or not you've got a lump sum saved to offset any deficiency, any delinquency. If your mortgage lender is sending back your payments, is not accepting your payments, you need to save that money, because when you enter into your agreement, they're going to want something in good faith. Next paragraph, describe your plan and your timeline for the plan. Set out a timeline, when it's going to be effective. You also need to include a financial statement listing your income and expenses, your assets and your liabilities. The lender's going to have paperwork for you to complete for that. Then you want to have supporting documentation. You need to have, depending on your situation, documentation of your income. That might be a pay stub or bank statements. If your foreclosure prevention tool is a short sale, then you're going to need to have a signed contract from the buyer included as part of your hardship letter in your documentation you're submitting. Otherwise, if the property's for sale, then you're going to want to have a signed listing agreement. Now, let's say, what if this is not working? What if you're trying this and your lender is not working with you? What do you do? One of the most important facets of a negotiation, and that's essentially what you're doing, you're negotiating with your lender, is to determine what the motivation of the other party is. In this case, what you need to determine is who bears the risk loss. In the event the property goes to foreclosure, who loses? Now, we've already determined that if you have $100,000 equity in the property, a lot of equity in the property goes to foreclosure, then you lose. Okay, the lender sells the property and is made whole again, and you lose. But in situations where there's not a lot of equity or there's no equity, if that property goes to foreclosure, who loses? If you have an FHA or a VA loan, then FHA or VA own the risk loss. What I mean by that is you have an FHA or VA loan, you make your payments to a mortgage lender, but if that mortgage lender forecloses and they sell the property for less than what is required to pay the loan off, then they file a claim with HUD or the VA and the lender's repaid. So FHA and VA don't want you to lose your home. So if you're negotiating a workout with your lender and if they're not agreeing to the terms that you want, then you need to get FHA or VA involved. So if you have an FHA loan, grab a pen. I'm going to give you a phone number on who to call if you are not able to come to terms with your lender. Contact FHA directly at 888-297-8685. 888-297-8685. If you have a VA loan, VA staff will intervene on your behalf. Here's the phone number for VA, 800-827-1000. If you have mortgage insurance and you don't qualify for one of the cancellations we talked about earlier, the way mortgage insurance works is if the property goes to foreclosure, the lender sustains a loss on the property, the mortgage insurance company pays them back a portion of that claim. So the MI company stands to lose financially if you lose your home to foreclosure. The MI company doesn't want to do that. So you need to get the MI company involved if you're having trouble with your workout with your lender. To find the name of the mortgage insurance company that you have, get your HUD-1 settlement statement from when you closed your loan, and look, there'll be a charge on there for mortgage insurance. Okay? When you get the MI company involved, your lender's going to be on their best behavior. If you have a first and a second mortgage, or a first mortgage and a HELOC, and the property goes to foreclosure and let's say sells for, the property is worth as much as the first mortgage balance, the second mortgage it's upside down. If it goes to foreclosure, the first mortgage gets paid back and the second mortgage loses. Second mortgage doesn't want to lose. So if you have a second mortgage or a HELOC as a second, get them involved in trying to help you with your workout with the first. Okay? What if, let's say now, what if none of these things are working and the property is still going to foreclosure? What can you do? You can file for bankruptcy protection. When a homeowner files for bankruptcy protection, they're protected through the creation of an automatic stay. The automatic stay puts a halt to the foreclosure process. It's only temporary, but it gives the homeowner time to come up with a solution. Now, one solution, when you have a first and a second mortgage, and the second mortgage is above the value of the home, bankruptcy allows the second mortgage to be stripped off through a strip down and eliminated. That second mortgage payment may have been the difference between making that home affordable or not. Okay, so that's very powerful. Another thing that people do when they file bankruptcy, let's say that you have a lot of equity in your property and the lenders they won't do a workout with you because you have $100,000 equity. So they're going right to foreclosure. You file bankruptcy, you put a stop to it. It allows you to enter into a repayment plan of 3 to 5 years where you're able to cure the arrearage. But what a lot of people do is they file bankruptcy, put a halt to it, and then they're making payments to the trustee. you can buy out of that bankruptcy with a mortgage called a bankruptcy buyout. A bankruptcy buyout pays off that mortgage that you've got, pays off the bankruptcy, and you start off again with a new lender. A problem, though, is, and a lot of mortgage brokers don't understand how this works, but a problem is that the mortgage company that was foreclosing, that you put a halt to through going to bankruptcy, when you make those payments to the trustee, they're continuing to report you as delinquent to the credit bureau. They're not reflecting the trustee payments. So there's a special RESPA rule, Section 6, called a qualified written request. You can go on the Broken Credit blog and do a search for qualified written request. And you'll find that all it is just a letter that you write to your mortgage company's customer service department, but you label it a qualified written request. And you dispute the fact that you are making payments to the trustee on time and your mortgage is not reflected accurately on the credit bureau for whatever period of time you list on there. The qualified written request, this HUD rule, requires that the mortgage payments of any amount that you're disputing for the next 60 days be removed from the credit report. The advantage is that that was affecting your credit score and your ability to be able to get a loan at a low interest rate through the bankruptcy buyout. So it's kind of an advanced thing that even a lot of mortgage brokers don't know. So a couple final things I want to talk about here. If you have one of those adjustable rate mortgages, like the millions of people in the United States that have the adjustable rate mortgages, and you could afford the payment before it adjusted, and now it's adjusting, has adjusted or is about to some amount that's higher that you can't afford, seek a mortgage modification. Remember, a mortgage modification can permanently change, can permanently modify that note. And this is something that's going on right now, is that you can convert that to a fixed rate or at least extend the adjustment period. Now, your lender may not want to do this for you. Your lender is in it for the money, and your lender may not want to keep you with the low rate. Remember, going back to that file that we talked about creating at the beginning of the seminar, that file, those closing docs that you've got from the title company, you need to get that information. If you're unsuccessful with your workout, if you've gotten to this point, and this is where you are, get that information to a consumer lawyer. Now, I recommend the attorneys at the National Association of Consumer Advocates, but get it to a consumer lawyer. If you know a consumer lawyer, great. What the consumer lawyer can do is they can check that paperwork to see if there are any violations, to make sure that all the I's are dotted and all the T's are crossed. To give you one example, there's the Truth in Lending Act. It's called TILA. Okay? It's a federal law. One aspect of that act is that it requires the finance charge that you were given as an estimate on a Truth in Lending form at closing. It should be a part of your package. It has a variance on the finance charge, and there's an allowable variance, and they're not allowed to go over it. So under TILA, if your last mortgage loan was a refinance loan, under TILA, if your finance charge was underestimated by over 0.5%, then you have an extended right to rescind the loan. So normally your rescission period was only 3 days. After 3 days you could cancel the deal and get a refund back of anything that you paid in those 3 days. But under TILA, if they underestimated your finance charge by over 0.5%, then you have an extended right to rescind the loan. You can rescind the loan 3 years later. Now, when you rescind the loan 3 years later, you get a refund back of all those closing costs that were paid as finance charge, all those fees, and all of the monthly payments that you've been making over that period of time, say 3 years, all of those go directly to principal. So your payoff is ridiculously low. Now, before you get too excited about this, 0.5% on a finance charge is a really big variance. It's a margin of error that they probably are not going to be over that amount. But if the borrower is going through any judicial or non-judicial foreclosure proceeding, if you're going through foreclosure, then TILA reduces that allowable finance charge to error to $35. So if they're off by over $35, then you have a 3-year right to rescind the loan. That's a powerful way for you to be able to get your work out. if they violated TILA, then you can force them to give you the loan modification that you want. Well, there's a lot more that we could talk about today, but I wanted to keep the seminar in general terms so it would apply to everybody. Remember that foreclosure is governed by state law, and the individual workout requirements are governed by the agencies we talked about today. I'm concluding the seminar now, but I'm not leaving you my audience because I'm only an email away here at paul@brokencredit.com. So if you would like me to refer you to an attorney that can help you with a legal defenses to foreclosure, or a real estate professional that can help you to find a buyer for a short sale, or a mortgage broker that can help you with a foreclosure bailout or a bankruptcy buyout, or any general questions at all, email me at paul@brokencredit.com. I want to thank you for spending today with me here on the seminar, and I'll talk with you soon. Goodbye for now.